Right, it says 10 a.m. It should say 1 p.m., but I'll go ahead and get started. Thank you for coming to National Consumer Protection Week. We did something like this last year where we had a big event all week with really amazing speakers, and we're so excited to bring it back again this year. So like I said, it is National Consumer Protection Week. You can visit the FTC's website for more information about maybe different events that they have. And then this is the one that we're having from the Texas Senior Medicare Patrol. We have a bunch of great speakers the rest of the week. If you came this morning, the Ombudsman was here. And now we have the wonderful Paul Zambie, which, I'll do a quick intro in a minute. But we also have great speakers the rest of the week as well. Of course, our little introduction about the Senior Medicare Patrol. It's a federally funded program, and there's one in every state in the US and 4 territories. So there's really 54 Senior Medicare Patrols. We recruit and train volunteers and professionals about Medicare fraud and abuse. So we are very volunteer oriented. We have a lot of volunteers that go out about the state of Texas that do what we're all doing today, or I'm doing today, is going and talking about Medicare fraud and how to prevent it and protect yourself. We also have a hotline that you can call to report suspected fraud. It's the best thing about our hotline is there's no menu, there's no press 1, press 2. You just call it and then a person will pick up. Unless it's outside of business hours, we'll get to you the next time we're in office. And our mission is to empower and assist Medicare beneficiaries, their families, caregivers to prevent, detect, and report healthcare fraud, errors, and abuse through outreach, counseling, and education. And if anybody is interested in becoming an SMP volunteer, like I said, we are very volunteer oriented. We can't cover the entire state of Texas with our staff of like 6. So we do depend on volunteers to go out and around talking about Medicare fraud. Our hotline number, it's a toll-free number. That's 888-341-6187, 888-341-6187. And anything that you talk about on the line. And now announcing our speaker from the Texas Legal Services Center is Paul Zambie. I'm gonna let him take it away, and just housekeeping. If you have any questions, please feel free to put it in the Q&A section. And I will, I'll read it to Paul when it's appropriate, and then we'll answer the questions throughout. So feel free to just ask whenever you do have questions.
All right, well, thank you, Diane, appreciate it. Again, my name is Paul Zambie. I'm an attorney at Texas Legal Services Center, and we have one office in Texas. It's in Austin, but we serve the entire state, and we speak Spanish. So all of the services that I'm going to be talking about, doesn't matter what county you are in, we will serve that county. And with that, I'm going to start sharing my screen. Because of bandwidth at home, I am going to stop the video feed to me. I think that kind of cuts into it. But like Diane said, for any questions, please put them through the chat and I will gladly answer those. If for some reason at the end, if there's time where we haven't gotten to some questions, I will give my contact information and you can have that, and you can feel free to give me a contact afterwards. All right, so right now you should be seeing my PowerPoint. And again, this is going to show up at the end as well, I think, but that's my email address for any questions that you might have. Who is Texas Legal Services Center? We were founded in 1977. We're a nonprofit organization and we manage more than a dozen practice areas. And again, we serve all 254 counties. And our mission is to ensure equal justice for all by providing legal advice, advocacy, and education. Some of our programs include a parenting order live chat and a family helpline. What these do is they actually will protect the rights of non-custodial parents A lot of the focus is on custodial parents, but non-custodial parents, they can explain suit affecting parent-child relationships. That's the calendar that you get for visitation rights. These folks can do custody modifications. A lot of the attorneys, or some, actually have CPS experience. They've been in there. They can do name changes. Again, they can talk about safety, custody matters, legal rights, things of that sort. We have our pension project. The attorneys that man this are like a couple bulldogs. They will find people money. You may have worked for a company for 20 years. That company may have gone out of business, merged, changed names, moved out of state, whatever it is. There's usually pension money still there, but people have trouble finding it. They will actually hunt them down, and this group actually pulls people out of poverty. They've done that in the past because they're getting people actually money in pocket when they otherwise would not have had that money. And something else they do when people get divorced, a lot of times pensions are not covered in there, and they can actually help that through something called a quadro, but they can actually find the spouse their rightful share of a worker's pension. We have our crime victims and our sexual assault programs. Again, these people do just what it sounds like. They assist with domestic violence, sexual abuse. They handle other violent crimes, things of that sort. These folks can also get you money through the financial compensation. It's crime victims compensation. They can actually appear in court for you, and they can appear on restraining orders, protective orders, things of that sort. They can give out resources on shelters and different things. And they can also assist with identity theft. A lot of times that kind of runs part and parcel with some of these other bad crimes. We help with social justice and discrimination, things of that sort. This group, Impact Litigation, they actually help groups of people. So, it doesn't matter if you are, immigrants, women, whatever it is, or just any population. It's people who are affected en masse. So they might live in an apartment complex and they're being overcharged on utilities, which shouldn't be charged. Their place may not be ADA compliant, and they can actually get things like that done. They have gone into school districts because of systematic sexual harassment and other inappropriate things. So it isn't just, one person, oh, I bought a car and it's a lemon car. It's actually groups of people who are affected, and they can actually file a lawsuit, appear in court, and they can actually fight for those rights. We have a very robust veterans program. They help with a whole host of things, which can be mortgage assistance, bankruptcy, foreclosure, evictions, wills and estates, credit card debt, Social Security disability, child support. If you're a veteran and you are within the program guidelines, they can actually advise on a lot of those things. And some of the things they can put pen and paper to are to actually restore your veterans benefits. You may have lost them because of a mistake or something like that. They can actually fight for you, and they can actually bring money into pockets as well that wasn't there before. We have an eviction helpline, and what happens there is that if you are being evicted, a lot of times it is for cause. I mean, this is a for-profit transaction. You're renting something for profit, but sometimes the landlords don't go about it the right way, or they have made some sort of an error. So they can actually fight to see if you are allowed more time in your home, at least for a softer landing. In the past, there was a robust set of money that would actually pay rent. It was called Texas Rent Relief. Well, that ended. It's a kind of funny we're doing this right now. It was just announced that that relief will actually come back for about 2 weeks' time. It's kind of crazy. It's like there's a little bit of money and it'll be back for a short period of time. But if you or somebody you know is experiencing eviction matters because they can't pay due to COVID and various other, ripples in the economy, there's actually going to be a little bit of money out there soon. So contact your attorney and people who help with evictions. They can actually maybe get you some assistance there. Accessing government benefits. This is one of the programs that I co-manage, and we help folks with Medicare and Medicaid benefits. We can counsel them on it, and there are certain things we can do that I'll be talking about soon. We do train on Medicare mainly, but also Medicaid benefits counselors throughout the state. So instead of people just having one resource, us to call in and ask question, we train the benefits counselors from all 28 area agencies throughout Texas, and they cover all 254 counties. So whatever your county you're in, they're covered by benefits counselors. We train them to handle matters, Medicare advice, appeals, things of that sort. We can train them to prepare advance directives and also counsel about long-term Medicaid, long-term care. So things of that sort. So a lot of our training is centered on Medicare, helping with the plan finder during open enrollment during the end of the year and various Medicare things. So today I'm going to be touching on a few of the more Medicaid aspects, which is more of a state program than Medicare, which is the federal program. And in a nutshell, long-term Medicaid, that includes things like nursing home, Star Plus, or in-home provider care. You can get a provider in-home to prevent you from going to a nursing home. Those aren't Medicare dollars that's a state program, long-term Medicaid. And it's different from Medicaid for children, pregnant women, or the disabled. This is for the elderly, again, nursing home or in-home provider care. Attendant with that, there are 3 eligibility basics. You need 1, a doctor's note, a letter from a doctor saying that you need to be in a nursing home or get this provider in-home care. And then there's also an income test and a resource test. In Texas, 2023, the income gap is $2,742. So if you are over that amount, you don't qualify for some of these programs. If you're under that amount, you do. But wait a minute. I mean, a nursing home alone can cost $6,000 cheap, and it's more usually in the range of $7,000. In fact, the average might be that $237 a month, a day, which is over $7,000 a month. So what if you have income of $3,000, $4,000, $5,000? You don't have enough to pay for the nursing home, but yet you are over the amount of that $2,742, so you don't qualify for Medicaid. So you not only don't get government help, but you still cannot afford going into a nursing home. So there is a solution, and it is called the Qualified Income Trust, which is also called the Miller Trust. And again, it is used when the applicant otherwise meets the resource asset provisions and also has the doctor's note, the medical necessity letter, but they are over income. And it's in the realm of just a too good to be true document. I mean, you literally can funnel all of your income in there and it comes out the other end, but yet you qualify for long-term Medicaid, even though you are over the 2,742 mark. Once you go in, it's kind of, I refer to as like a sausage grinder. You put the money in, what comes out, it's $60 that goes directly to the person who's in a nursing home or at home. There's also a provision in there where you get to pay a spouse, if there is one that is still living, that is not in a nursing home. They get a certain monthly minimum allowance. And also doctor's bills can get paid out of there. What remains then goes to the nursing home. And let's say that their bill is $7,000 a month. And because you've paid all these other things, the remainder is only $1,000 that goes to the nursing home. That's when the state makes up the difference and Medicaid pays the difference there. So they may pay $1,000, they may pay $5,000, whatever it is. When somebody passes away, any funds that remain in the trust do go back to the state. It can only be used for nursing home, Star Plus, and in-home care. It cannot be used for something which help pay for Medicare programs, the QMB, SLMB, QI, community attendance, things of that sort. Those are kind of hybrid programs where they're Medicare programs, but they are paid with Medicaid state dollars. So it's a federal program, and these programs can help you pay for parts A and B, various things, and they're great to have. If you are over the income limit for those, you cannot use a qualified income trust to get you below that. It is only for, again, nursing home care, Star Plus, and in-home care. This is something that Texas Legal Services can actually put pen to paper to, and we can actually fill those out. A lot of times it's a referral from an area agency. With permission, we can actually talk to them, send them paperwork. It can be sent from them, whatever's easiest for the individual. But this is something that we can actually do for folks. Okay, so if you have the doctor's note, then we've talked about what to do if you have too much income, and that's the qualified income trust. Well, now we're going to go on to resources, and these are the assets. So what happens if you have too many of those? So to qualify for long-term Medicaid, you can have, they don't count the first home up to $636,000. They don't count the first car, and $2,000 in cash. If you are below those amounts, you qualify for Medicaid resource-wise. Well, what happens if you have above those amounts? Well, if it's not a whole lot of money, $10,000, $20,000, it's possible that you can spend that down, and you can spend it down on legal items and permissible items. It can be life insurance policies, $1,500 or less, burial policies, $1,500 or less. You're allowed to replace vehicles, repair vehicles, update and repair your home. So if you needed a new roof or a new AC system, something like that. If you have credit card debt, perfectly good. If it's your debt, you can pay off your mortgage. You can get medical supplies that you need. If you still have too much, there are certain legal tools called annuities. There are certain companies out there that handle these, and you actually can put your assets in there, and out the other end, it will come money. And if you are not over the income limit, then you can actually qualify for Medicaid that way. So what happens though if there is a spouse at home? So do you have to spend down, let's say you have $50,000, $100,000, whatever it is, do you have to spend it down to $2,000 just so you can get into a nursing home? Well, your spouse at home then becomes destitute. So it used to be in the old days that that's what would have to happen, or folks would be forced to get divorced, and the money would be transferred to one spouse. The spouse who was going into a nursing home would have very little, and so they would lose a lot. But you have these couples married 40, 50, 60 years having to get a divorce, and that was not very appealing. So what came into play was called the spousal impoverishment laws. And these are used for a spouse at home, and they are allowed to keep a lot of the extra money. This topic can be really the source of an entire another hour program. The same as the qualified income trust. There's a lot of nuances to these things. Just know that if you do have money and one spouse is going into a nursing home, one spouse is staying out, the spouse at home gets to keep over 29,000 of your community assets, and up to 148,000. So again, minimum of 29,000, maximum of 148,000. That is just great for the spouses at home who don't have to become destitute. And the same goes with income. We were talking about assets a second ago. the spouse at home gets to keep a monthly allowance. So let's say that the spouse who's staying at home only gets about $600 in Social Security, but the spouse going in has a Social Security, they have veterans benefits of $3,000. Well, is that $3,000 going to be taken away from the family unit and go into the analysis and be paid to a nursing home? No, a spouse at home gets to keep a lot of the spouse's money who's going into the nursing home. So they get to keep up to $3,715. Again, these are wonderful laws that were passed because it was not pretty before they were enacted. That brings us to something called the transfer on death deed. And by the way, Diane, if you can hear me, were there any questions in the chat based on some of those other topics?
I haven't seen any questions yet.
Okay. So we talked about the qualified income trust. That can actually help you qualify for long-term Medicaid. The spousal impoverishment laws, same thing. You can go through an analysis and you can transfer money, and that will help you qualify for long-term Medicaid. I want to talk to you about the transfer on death deed. This does not help you qualify for Medicaid, but you need to think of Medicaid in two parts. One is eligibility, getting on it. The next part is once you're on it, can you protect your assets and pass them on? So this is the second part. It does not qualify folks for Medicaid, but it gives you peace of mind that you can get on Medicaid and you can still keep your home in particular. So think of the transfer on death deed just like a will. It's something that you do when you're alive, while you're still mentally competent. It does not take effect until you pass away, just like a will. It is better than a will for two huge reasons. The first is that it avoids probate. So if you have a will and you leave something to somebody as big as a home or as little as a kitchen table and chairs, and they take under that will, they have to go through probate, which means that they have to hire an attorney. It's a couple $1,000s. You're in the court system for several months, and when a judge finally signs off, then you get title to the property. With a transfer on death deed, you're going to wait 1 week when somebody passes away. You're going to file something for $50 and it's over. And that's one great reason to do the transfer on death deed. So every property owner in Texas should avail themselves of that. But an even bigger savings is that it protects from Medicaid estate recovery. And we're going to be going over that in a little bit as well. Todd's fairly new in Texas. It's not quite 10 years old now, September 2015. So if you did a set of wills and other estate planning before that time, this would not have even been a tool that you could have used. They had something called the Lady Bird deed, and that has existed for 35 years, whatever it is. But that was no Texas law, and only about 5 to 7 states accept a Lady Bird deed. Texas is one of them. But because of that, the legislature said, wow, we have this thing where there's no law behind it. Let's enact one. So they did Chapter 114 of the Estates Code, and that is where the provisions of the transfer on death deed are found. A majority of the states now do have transfer on death deeds, or they call them beneficiary deeds. Every state would have their own form. So a form in Texas wouldn't be good for one in Oklahoma, and vice versa.
Hey, Paul, there's a question in the chat.
Sure.
So if a couple is over $2,000 in resources and income, do they have to submit a QIT in order for the spouse to keep those amounts you mentioned?
Well, when we talk about trusts, everybody, when you think of a trust, it's putting your stuff in there, your savings and homes and things like that. A qualified income trust is only for income. So you don't put any assets in there at all. It is only for your income. So let's say that you have Social Security, $1,900, and then a veteran's check of another, $1,500, which puts you over that 2724 magic number. So it is not for if you have excess assets that are over $2,000. It's excess income that is over the 2742. I hope that answered the question. If not, you can ask a follow-up question on that. With the impact of dying without a will. If you have nothing, you should at least have a will. I mean, the reason that we prefer transfer on death deed over that is because it avoids expensive probate, but you should at least have something. Well, what happens if you don't have anything? Then it's kind of up for grabs. Let's say that you own a home and you may have had in mind that you want it to go to one specific person. It may be a son or daughter, age 40, 50, 60, who's been with you their whole life. They've given up their life, their job to take care of you, and you've promised them your home. And you even told everybody else in the family, I want Johnny to get my home. Well, when you die, how much is that worth, that promise? I mean, you have to have something written down. And let's say that it does go to 3 or 4 of your kids, whatever it is, and they may not have helped you throughout your life. They may not even get along. And one of those kids may want to keep the property. One may want to sell it. One may want to rent it out. If they can't agree, they're all owners of the property and things are not going to get done. So it's so much better if you can unify title and just designate who you want to get your property, because we find that people start to fight. One may get angry and not pay their share of the mortgage, the insurance, the upkeep, whatever it is. And that burden shifts to the others who may be unwilling or unable to cover those amounts. So we've seen houses actually get foreclosed on because of taxes. It results in abandonment, and then you cannot pass it on to your kids. So it's difficult to pass that wealth on to your heirs. And there's also the matter of a false sense of security. So let's say that you are a 50 or 60-year-old person, mom or dad dies, let's say you're the only child. What's the first thing you do? Your instinct is to go down to the tax office, because they're the ones who want money from you on a yearly basis. And you give them a death certificate and prove that your parent has died, and they say, great, we'll put your name on. And so they put your name on the taxes, and every year you're paying the taxes. And you may be doing that for 2 years, 5 years, 10 years, whatever. That has nothing to do with who owns the home. The county will gladly put your name in there so they get their money, but you've done nothing to get it out of that deceased person's name. So that is a problem. And so you have that false sense of security where you've been paying your taxes for 10 years just in your name, but you really don't own the property. And that's a very, very common problem that we see. So benefits of a TOD, again, there are statutory free forms out there, so you can save hundreds of dollars by not needing to get a will. In avoiding probate, your family, when you pass away, can save thousands of dollars by not having to go through probate. But again, if you can save your home, that's either tens of thousands or hundreds of thousands of dollars, because it will protect it from Medicaid estate recovery. So I get that question all the time, Paul, do I need a will? Well, sometimes you would like a will in conjunction with this, maybe of some complicated business matters or certain bequeaths that you would have. And a TOD's a fairly simple document. It gives straight ownership to people. But let's talk about Medicaid estate recovery, because this is really huge. And this is one of the reasons why a lot of people actually don't get needed services that they're eligible for, because the nice folks from Health and Human Services, DADS, comes in and they will determine whether somebody is eligible or not because they need a nursing home or in-home care. And they say, great, you're eligible, but you need to sign this paper that you understand that we have this program in Texas, Medicaid estate recovery, that can take your home away from you. And right then and there, you have a lot of people who just walk out, turn around, and they don't get those services, because even though they really need to be in a nursing home or need that in-home care, They figure if they have to give away the only thing that they've spent their whole life working for, even if it's a modest house of $60,000, $70,000, $80,000, whatever it is, then they're not going to get services. And we see that happen all the time. The TOD will protect from Medicaid estate recovery, which again, you're getting nursing home services, in-home provider care, or that STAR Plus. So a lot of people know a little bit about Medicaid estate recovery. They have a neighbor, a family member, or something that said, my gosh, we heard of a home being taken because of Medicaid estate recovery. And so then they try and get cute. They say, well, mom or dad's going to need these services in a couple years, but they own a home and we don't want the home to be taken away. Boy, let's be smart and let's transfer that home now to son or daughter who's aged 40 or 50. And then when we apply for Medicaid, they'll never even know about it. And then they'll qualify for Medicaid and they won't lose the home. That is the wrong thing to do for several big reasons. The first reason is that Medicaid, when you apply, they look back 5 years, 60 months to see if you have done just this. You're not the first person to think about doing something like this. So they have installed this policy where they look back 5 years. And if you have transferred anything, they're going to ding you for it. They're going to deny you services, delay you services, whatever it is. So that is a problem if you transfer something during your lifetime. If you do the transfer on death deed, you're not violating the 5-year look back because you're not giving anything away when you sign and file the documents. It's a transfer on death deed. So it transfers upon your death. So thus it does not violate a 5-year look back or anything like that. But we have a lot of folks that they are penalized, and that figure in one of the earlier slides where the daily rate for a nursing home in Texas is $237.93. Well, what they will do is, let's say that you gave something away, even if it's cash, a car, let's say it's $10,000, they're going to divide that monthly by the $237. And that may take several years for you to kind of work out of that, but they're going to get that payment. And I'm sorry, $237 a day. But they're going to deny you services until that money is used up. So who qualifies for a transfer on death deed? It is any property owner in Texas. We're a legal aid and we normally help those who are lower income, but this program is for any age or any income level. It is only good for real property. What does that mean? So real property is something that is built on the land, like a home, a barn, trees that grow, timber interest rights, things like that. It is not good for personal property. So it's not good for furniture, guns, clothing, jewelry, stuff like that. There can be other ways of disposing a lot of that. And at the end of this program, before we finish, I'm going to tell you the simple ways of avoiding probate. With just a few simple things. The TOD is one of those that is included. Powers of attorney can be very, very important documents, and they can help folks with medical issues, financial issues, if you can't make decisions for yourself. And a lot of real estate things can be done with the power of attorney, not so with a transfer on death deed. For a transfer on death deed, you have to be mentally competent in order to execute one. So it cannot be signed by another who holds power of attorney over you. If you have multiple properties, you have to do one per property because each has its own specific property description on it. It is only, again, for real property, not personal property. One little trick there that we see every now and then is that somebody says, yes, I own a home and the land underneath it, so they want to do a transfer on death deed. But it comes out, we find out that their home is actually a mobile home or manufactured home. Those things are not covered by the transfer on death deed because you can move them off of the property. So if that is the case, there is a solution for it. We would have you contact our Texas Department of Housing and Community Affairs, and they can actually convert the legal description of that mobile home or manufactured home, double wide trailer, whatever it is, from personal property to real property, and then it will transfer with the transfer on death deed. It transfers whatever interest you own at the time of death. So I get those calls all the time. Paul, I haven't paid off my home yet. You know, I still owe $40,000 to the bank. Can I do one of these? Yes. If you execute one and you pass away before the home's paid off, you may be transferring $200,000 in equity, but you're also transferring a debt of $40,000 that will have to be taken care of. But you can absolutely do that. Paul, I don't own the home because I own it with a spouse, a child, a brother, whatever it is. I only own a third, half, fourth of the house, whatever it is. Can I do one of these? Yes. You can do it for your portion, even if it's a third, a fourth, or a half, whatever it is. So you can still do a transfer on debt deed if you don't own the whole thing because you haven't paid it off or you own it with somebody else. All right. And the requirements of a transfer on death deed, fairly simple. You need names and addresses of grantor. There is a legal description, which is the only tough question, and that has to be gotten from the deed that gave you ownership of the property. A lot of people see that and they directly go to the tax office because they have seen that there's a legal description there. And it's something like Lot A, Block 4 of the Davidson subdivision, something along those lines. But that has to be gotten from the deed that gave you ownership of the property. It is not gotten from anything from the tax office. All TODs have to be notarized and filed in the county where the property is located before somebody passes away. So again, if you own a home here, you also own one in El Paso, you can't file both of them in Austin. You have to file each separate one in the county where it's located. And boy, we've gotten those calls all the time. Boy, my dad died without a will. Can we do that transfer on death deed? No, it has to be executed before somebody passes away. And this is where you'd like to help people. There's a lot of maybe social workers, benefits counselors who see the need for this. You can do a transfer on death deed yourself because there's do-it-yourself forms. You can hire an attorney to do it. You're not supposed to be helping others with this. And again, that's what benefits counselors and social workers do. You know, they have a list of clients and they help them. But if there's a mistake made on one of these things, you can be held liable. This is the unauthorized practice of law. So you have to watch out for that.
There's a question.
Sure.
Can you please repeat explanation of mobile homes? Are manufactured homes and mobile homes the same thing?
Okay. They're a little bit different. So I think the statute says manufactured homes. It's mainly trailers and, you know, like double wide trailers. If you actually have something with a motor in it, like an RV, which has a motor, that is treated more like an automobile. And there is a solution for that. They call it the TOD for the cars, but it's a Texas Department of Motor Vehicle form. I think it's it's VTR 121. And that's going to be the form that you would use if it has a motor in it. But if it is not stick built on the land and it doesn't have a motor, then it's a manufactured home. And that's the ones that have to be legally changed from personal property to real property. Back to the form, who can you leave it to? the form has a lot of leeway there. You can leave it to one person only. You can leave it to 10 people if you want. You can leave it to one person, and then you can put a number 2 down if that first person dies before you pass away. So, and again, you can do multiples on either of those. This is where I tell people, though, that in general, it's best if fewer people own property than more. You may have 10 kids and they may all want their share, and that's great. If you put all 10 of them on it, and again, they don't get along, if one of those folks doesn't want to sell the property and the other 9 do, it doesn't get sold without court intervention. So a lot of times what people will do is they'll leave it to 1 or 2 trusted people with the knowledge that they really trust them, and they will dispose of it and they will split the money, make sure everybody gets their fair share. Sometimes you come across what I call mama loved you best syndrome, and people get kind of offended. Hey, why'd you leave it to them? But you're allowed to leave it to as many people as you want, or you may leave it to 1 or 2. That's just kind of a family situation there. And you can do whatever you want. But that is one thing that that the TOD is just very good at, allowing you to leave it to multiple people and leaving it to your second choices. TODs versus wills. So with a will, it has to be signed, it has to be notarized in front of witnesses, and then you need something called a self-proving affidavit. It does not need to be filed anywhere. You can, but it does not need to be filed. If you stick that under your mattress, it's a perfectly good document even 30 years later, okay? Not so with a transfer and death deed. You do not need witnesses on that. It is only notarized, and then it gets filed at the county clerk's office. If you fill it out properly and notarize it and just stick it under your mattress, it's not worth anything. If somebody passes away, it's not a good document. It has to be filed before somebody passes away. So what if you had done a will 6 years ago and you like what it says, but now you want to change beneficiaries, or maybe one of you're going to leave the house to, they got on drugs, they're in jail, maybe they have bankruptcy, they have a huge lien against them, maybe they've passed away, maybe they've won the lottery. So now you do a transfer on death deed and you name somebody else. So Johnny was named in the original will, Susie's named in your transfer on death deed, you pass away. Who gets the property? The TOD says one thing, the will says another. Whatever's listed in the TOD is what controls. The will is more of a fallback document, and the TOD, whatever it says in there, is going to trump whatever it says in a will. I put the little designations there, separate property versus community property, to kind of illustrate a point. Community property, as we all know, is property that a married couple gets together, whether it's earnings, whether they buy a home, it's something that was acquired during your marriage with marital funds. If you got it before you were married, so you bought your home a week before you were married, that's your separate property. If you were married and Uncle Wally left you either money or a home, he either gives it to you or he dies and leaves it to you, that's your separate property. So your other spouse is not on the deed. And then only you would have to do the transfer and death deed. Your spouse would not need to be on there. So community property, though, this is another one of those false senses of security. You figure it's community property. Every dollar I earn 50 cents is his or hers. So it's the same thing with a home. If we buy a home, we don't need anything special. If I die, it goes to the other person. That's not the way it works in Texas. You still have to do a will or a TOD or something else. But we've had those calls where a spouse has been dead for 15 years or something like that. And the one calling us says, well, yes, my husband died, so it went over to me automatically, and now I own the home. That's not true. They probably own 1/2 of the home. They don't own the other half. And that can be a huge problem later on for that other 1/2. And it's especially a problem If this is maybe a second marriage and the spouse who died had kids from a previous marriage, then his share will probably go to the kids instead of the spouse who's living in the house. And that sounds just crazy, but again, if you die without a will or anything else designating that, bad things can happen. So you have to watch out for that. What is the effect of a Todd filing? So you've got the proper form, you filled it out correctly, you go down and you pay less than $50 to file at the county clerk's office. What's the effect of that? The effect is zero. This is a transfer on death deed. So it's just like a will, nothing passes until you pass away. So during your lifetime, you have retained all the rights and responsibilities. You have to pay for all taxes, mortgage, insurance, upkeep. Just because you name somebody on there doesn't mean that they're on the hook for that. But by the same token, let's say you wanted to sell the property or get a mortgage on it, only your signature would be needed. And even if you told your family, hey, I'm leaving it to your 3 kids, you're still allowed to sell it. Even if they bring up the Todd and say, look, you filed this, it has our names on it. Nope, until somebody passes away, interest has not transferred. So there are no interests in beneficiaries until one passes away. The only thing there I tell you, you need to worry about is watch out if you're leaving it to somebody who is on government assistance or public benefits. If this is a second home to them, this is going to be considered an asset and may kick them off of that. So you need to watch out. By the same token, though, it is not reachable by beneficiaries' creditors. So let's say that you don't want to leave it to someone because they have a huge child support lien or they're owed money and they're afraid they can attach it to the house if you transfer it to them. If you name somebody and they do have those things during your life, the beneficiaries' creditors can't get it because no interest is transferred. Only upon transfer then can the beneficiaries' creditors try to reach out and grab part of that. In the real world, how do you receive the property through a Todd? When somebody passes away, their heirs are gonna file a death certificate and the affidavit of death. It's a special other form, and that coupled with the transfer and death deed serves to kind of solidify the transfer process. And then they really just step in the shoes of the person who passed away. They would pay taxes. If there's a mortgage and it is a family member, a direct family member, they would just continue with the mortgage payments. That's what banks usually do in Texas. But if you leave it to your neighbor or third cousin removed or just your best friend, the banks can then come in and say, hey, we need to see if you can really afford this. But if it just goes down the family line, banks usually leave it alone there. Again, creditors have up to 2 years in which to refile their claims when somebody passes away on a property like this. And when we talked about it protecting against Medicaid estate recovery, it's great for that, but it isn't a magic bullet that affects everything. I mean, if you had work done on a roof and you didn't pay it, that lien can follow it. If you owe child support, these things follow it. So it isn't good for other debts. Mortgage, taxes, those are still due, but it does protect against Medicaid estate recovery. So, Paul, you keep telling us you need a will, you need something to do when you pass away. Well, darn it, it's too late. One of my parents died and they did not have a will. So what's the solution when you do something like that? When somebody dies intestate without a will, they can do one of 2 things. They can hire an attorney and they can go to court in front of a judge and say, hey, these were all of the heirs, and they will list spouses and kids and grandkids and things like that. Our clients usually can't afford to do that. But if you do that, going to court, that's kind of the quick way, meaning a matter of months, less than 6 months, but then you get a judge's signature and then you're free to go about your life, do whatever you want. A lot of times my clients do what's called an affidavit of heirship. It's the same proof. You're just writing down on paper the spouses, the children, the grandchildren, things of that sort. And all that is, it's filed at the county clerk's office. That's the cheaper way of doing it. The problem is it can take a long time because mortgage companies, title companies don't have to accept that until it's been on file uncontested for 5 years. So if somebody contests it, you got to worry about it. Now, in real life, I've seen banks and title companies accept it immediately after it's been filed. Sometimes they just want to know that it's there. But again, this contributes to one of those false senses of security. You figure that you don't need to do anything when your dad or spouse dies, but you do need to do something. The form has to be signed by a disinterested third party. So anybody who can possibly inherit should not be signing this. It should sign by optimally 2, but at least 1 family friend, neighbor, church member, something like that, who knew the deceased. And again, this has to be filed at the county clerk's office, usually for less than $50. Revocation, and again, we're at the end of our slide set pretty much here. It's called a revocable transfer and death deed, but a lot of people think, my gosh, I had this notarized and filed it, it's set in stone and I can never change it. Well, that's not true. I mean, you can straight out cancel it. If you file a new transfer on death deed, that kind of revokes the old one, so newest one in time rules. If you listed your spouse as the main beneficiary and you get divorced, and it's filed in the county there, that spouse is taken off of there. If you sell the home, I mean, that is a way of revoking it because again, you're allowed to sell it. So once you die, if there's nothing there to give away, it's a null and void document. Again, we had talked about the wills and the TODs. Again, just by tearing up a will, that's perfectly fine to say that you don't want anybody to take under that. You can't do that with a transfer on death deed because it's been filed. You have to do something usually down at the courthouse, down at the county clerk's office in order to revoke that. So again, we serve all 254 counties. We're Spanish speaking, all of our programs. You can see what services are offered by us at tlsc.org. And we have a great do-it-yourself website, texaslawhelp.org. I'm going to tell you how to, just the basic steps on avoiding probate. And I'm going to leave you with this resource page here because these are the numbers to those programs that I told you about at the beginning of this. Our Pension Rights Project, our eviction hotline, our crime victims, things like that. But on avoiding probate, when my dad passed away 3 years ago, we did not have to probate anything. We did a few simple things and we put them in place, and you don't have to go down for that expensive, time-consuming, and painful probate. So you can consider probate as a transfer of title, and that's what you're doing. And your 3 things with title are your home, your bank accounts, and your car. So if you do the transfer and death deed for the home, you don't have to worry about that, and you don't have to go through probate. There is a similar one for the car, and I said that was VTR 121. There's also another one, VTR 122, but one of those will do it. And again, those are Texas Department of Vehicle forms. So your bank accounts. This is important because people get tripped up on this a lot. I get calls all the time where banks will not let a spouse or kids get access to the bank account. So most people, when they open up an account, might have it just in their name, and that's fine. They're the only ones who have the right during their lifetime to make deposits and withdrawals and things like that. But the problem is when you pass away, if you haven't named anybody, a bank is going to ask you for a judge's note or a letter, something signed before you get it. And that means a kind of like a probate action. And you're like, well, I've heard that attorneys can charge $2,000 for that. Can you tell me how much is in there? If it's $300, I'm just going to let it go. If it's $6,000, well, I'm going to do it. Banks don't even have to tell you what's in there. So maybe a better way of doing it is to have somebody on as a joint account holder. And that way, during your lifetime, this can be very useful for somebody trusted. They can go down and make deposits and withdrawals because their name is on there as well. The two problems there is that, well, we've heard stories about somebody taking all the money, one person taking all the money, and the other one says, I'm going to call the police. They took all my money. Well, no, it was just as much their money as yours because it was a joint account. Or if that second person has creditors, child support, taxes, whatever it is, people can get to that money then. So watch out for that. Maybe a better way of doing it is if you list somebody as what's called POD, or payable on death beneficiary. And that way, during your life, only you have the right to go make deposits and withdrawals. But when you pass away, you have listed somebody to receive those funds by designating them as a payable on death beneficiary. And if you do all those things for your home, your car, and your bank accounts, you don't have to go through probate. So a lot of my clients don't even need a will. That is it for my program. Diane, were there any other questions?
No, that was all. If anybody has any questions, please ask them now. We're wrapping up the end of the presentation. But there doesn't seem to be any questions. Any other questions?
Okay. And again, if you would like to contact me later, Diane has my contact information, and feel free or call one of these numbers. On this screen here, the legal hotline for Texans is the one that I co-manage. So you can always call that and reach me there as well.
Oh, there is one question. Are you helping prepare the TODD?
So currently we do not have a grant to prepare the transfer and death deed. Best I can do now is I can send you out a free form. And if you have questions on the form, I can answer it for you. I just can't put pen to paper for it. And other than that, you would have to find a group that does it or hire someone to do it. A good price for an attorney would be somewhere between $150 and $250. When it gets above that, $400, $500, and $600, that may be a little much for that.
Looks like that's all the questions.
Well, Diane, I thank you for the opportunity to speak today.
All right. Thank you so much for speaking for us, Paul. Thank you to everyone for attending, and I hope to see you guys the rest of the week for our other lovely speakers.
Okay, bye, everybody. Thank you.